Welcome to Term Talk, the video podcast for the Federal Judicial Center that discusses the Supreme Court term opinions with the most impact on lower courts. I'm Francesca Williams, education attorney for executive education at the Federal Judicial Center. We're going to discuss two opinions that consider the impact mental health can have, both on what can be criminalized and how it can be punished. Joining me to do this are Laurie Levenson, professor and David W. Burcham Chair in Ethical Advocacy at Loyola Law School, and Evan Lee, Emeritus Professor at University of California Law, San Francisco. Thank you both for being here today. Let's start with Grant's Pass. Evan, this case considered the criminalization of status, but turned on the Eighth Amendment's prohibition of cruel and unusual punishment. Can you review both of those concepts for us, please, and help us understand how they apply to this case?
Sure. In 1962, the Supreme Court decided a case called Robinson versus California, holding that a state law couldn't criminalize narcotics addiction because that constitutes mere status and therefore violates the cruel and unusual punishments clause of the Eighth Amendment. In 1968, the court followed that up with a decision called Powell versus Texas, distinguishing Robinson and holding that a statute punishing public intoxication did not violate the Eighth Amendment because even a chronic alcoholic could only be punished for the voluntary act of appearing in public while intoxicated. So in this case, the city of Grants Pass, Oregon, has three relevant ordinances. One prohibited sleeping on public sidewalks, streets, or alleyways. A second prohibited camping or overnight parking in city parks. And a third, which perhaps has the widest potential reach of the three, prohibited camping on public property, with camping defined as setting up or remaining at a campsite, and campsite defined as any place where bedding, sleeping bags, or any other material used for bedding purposes is placed for the purpose of maintaining a temporary place to live. And these ordinances were punishable by civil fines, exclusion orders, and potentially criminal penalties. The Ninth Circuit held that these ordinances violated the Eighth Amendment, and in so holding relied upon its famous opinion in Martin versus the City of Boise, which was decided in 2018, involving a similar ordinance of Boise, Idaho, and holding that the cruel and unusual punishments clause was violated if criminal penalties are imposed on homeless people where there aren't enough beds available, and therefore they had no alternative but to sleep in a public place. But the Supreme Court 6-3 reversed and held that the Eighth Amendment was not implicated here.
Thank you. Laurie, what's the court's reasoning here?
Well, Justice Gorsuch and the court fully recognize how complex this issue is regarding homelessness, and that it faces cities throughout the nation face this issue. It involves things like sanitation and drugs and medical care and public safety. And cities are trying different approaches in dealing with it. And it's not an issue, frankly, that's resolved even if you have beds for the unhoused, because not all the homeless want to participate in the shelters. So the court started to take a look at this, and you get very much the sense that the justices thought, frankly, this is more of a due process issue as to what can be criminalized than an Eighth Amendment issue of what the punishment should be. On the other hand, this was an ordinance that has a fine and up to 30 days in jail. And so the court had to take a look at the precedent, which is under the Eighth Amendment when it comes to this, Robinson, and held that it's not cruel and unusual punishment. So the court took this background and precedent and took a look at the Grants Pass ordinance and says, you know what? This is not Robinson because it's not status. This is something that applies to everyone, whether it be backpackers or protesters and the like, so that the precedent that applies is actually Powell versus Texas, because what you had here was conduct. In Powell versus Texas, the people being prosecuted were not being prosecuted because they were just drunk or people who get intoxicated. They were intoxicated in public, and that focused on, in fact, their conduct. So the Supreme Court here said that, look, it's difficult to determine whether homelessness is voluntary or involuntary, but there's no reason to overturn Robinson because it's not before them. This is not a status case. This is a conduct case. And the court did look at the language by Justice Marshall and Robinson and said that if they expanded that, that would give judges the authority to dictate how jurisdictions across the country would deal with such complex issues like homelessness. The court, however, did say that even though it wasn't striking down the ordinance on Eighth Amendment grounds, individual defendants might still have defenses, things like necessity. But that's not what was at issue in this case.
Well, Justice Sotomayor wrote a dissent joined by Justices Kagan and Jackson. Evan, how did they see this differently?
Justice Sotomayor emphasized that the injunction here and in the Ninth Circuit Martin case only covered homeless persons who truly had no other place to sleep. It doesn't include those who refused offers of a place in a shelter. And she said, once you take those people out, Powell versus Texas becomes inapposite and Robinson becomes the controlling precedent. And if you're not going to overrule it, then it controls here. And Robinson does hold that mere status may not be punished, consistent with the cruel and unusual punishment clause of the Eighth Amendment. And then more generally, she says, homelessness is a status if the person can't possibly do anything about it. There's 600,000 homeless people on any given night. The reasons for homelessness are many and varied. They're physical and psychiatric disability, crippling debt, abuse, costs of housing, and criminalization can lead to cascading harms. But finally, Justice Sotomayor emphasized that this majority opinion is limited. It only addresses the cruel and unusual punishments clause of the Eighth Amendment. It does not, for example, address the excessive fines clause of the Eighth Amendment, nor does it address, as Laurie referred to earlier, the due process clause. It leaves open the possibility of a future challenge under due process. It even leaves open the possibility of a future challenge under state law. For example, the state of Oregon has codified the Martin decision in a statute. And so that potentially is available for future litigation.
Thank you, Evan. Your takeaways for the lower courts.
What is important here is that the Supreme Court did not overrule Robertson. So it is possible that some format of that might be used in future cases, but the court certainly signaled that he thought that these situations are better addressed under due process. And so we're going to see if there's more opportunities for people to challenge aspects of these laws in the future.
Well, let's turn to McElrath v. Georgia. Laurie, this case sets the issue of double jeopardy in a tragic context. Can you take us through the issues and facts of this case, please?
Let me start with an overview of double jeopardy for everybody. The Fifth Amendment prohibits the prosecution of substantially the same crime by the same sovereign more than once. Doesn't attach until a jury is sworn, or if you have a court trial once the first witness testifies. So if you have double jeopardy attached, and then you have a trial, you have to take a look at what happens in the verdicts. So the issue that came up in this case is whether when they had inconsistent verdicts, the prosecution could go back and retry something that was found to be an acquittal under the Georgia law. Now for the facts, and they were tragic. The defendant, Damien, was adopted when he was only 2 years old by a single mother. He was later diagnosed with bipolar disorder and ADHD. He frequently quarreled with her and then started suffering delusions. At that point, he was committed to a mental health facility where he was then diagnosed with schizophrenia. A few weeks after leaving that facility, he went home and he stabbed his mother to death. And after calling 911, he waited for law enforcement to arrive. He was then charged under Georgia law with malice murder, felony murder, and aggravated assault. They found him not guilty, the jury, by reason of insanity on the malice murder. But they also found him guilty but mentally ill on the other two charges. And that created a situation going up on the Court of Appeal of inconsistent verdicts.
Evan, can you walk us through the court's analysis on these issues?
Yeah, because of the disparity in the verdicts that Laurie just mentioned, Damien appealed and he requested that the two lesser charges be vacated. But the Georgia Supreme Court instead vacated all of the verdicts and ordered a new trial. Justice Jackson wrote for a unanimous court. She said the acquittal on the malice murder count bars retrial on malice murder as well as on the other two counts. State procedural law cannot defeat the double jeopardy clause. Courts will not inquire into the jury's reason for acquitting, whether it's compromise or compassion or lenity or misunderstanding. The courts just aren't going to look into it. Justice Alito concurred. He said, let's be careful to note that this opinion does not address the situation where a not guilty verdict has come in that under state law is inconsistent with a verdict on another count and is not accepted by the trial judge. That's a different situation. It's not covered by this opinion.
Thanks for that analysis. What are the takeaways here for the lower courts?
It's understandable that state courts want to apply their own familiar procedural rules concerning the handling of criminal verdicts. But if those rules are inconsistent with the federal double jeopardy clause as applied to that particular case, then they have to give way.
Laurie, can you close us out with a final word?
Yeah, as Evan has suggested, there's a concurrence here that Justice Alito says, and there's footnote 4 of the opinion that emphasizes that federal law does not prevent the acceptance of inconsistent verdicts, nor does the Constitution mandate it. So how those situations are going to be handled will be up to the states and their jurisdictions. This opinion, in my mind, stands only for the proposition that acquittals may not be challenged without violating the double jeopardy clause of the Fifth Amendment. And it doesn't matter, as Evan said, how the jury got to that acquittal.
Well, thank you both for joining us today and helping us understand these very complicated issues. Appreciate your time.